check this in the courtroom. The jury was here too, by the way. We're here. The start of jury trial today. The defense filed a motion of notice of intention to introduce expert testimony Friday. We had some conversation about that as a group. The telephone. State has filed the response, and see where Mr. Weiss filed a response to the state's response as well. So let's just start from the top. It is the state's motion. So if you want to argue, Joan.
Your Honor, it is the state's response.
State's motion to exclude defense testimony.
Sure, Your Honor. And the state did file, as the court just noted, a lengthy response with much law included. Procedurally, for the record, the parties were in Davidson County on the 8th and the 9th of last week to choose a jury. Mr. Chen had been transported on January 6th to Davidson County Jail. Jury selection began promptly on the 8th and ended in the late afternoon of the 9th. The court did inform the parties that court would be closed on January the 10th due to inclement weather. Friday, January the 10th, all parties, including Mr. Chen, were back in Hamilton County. And at approximately 2:15, the state received notice from Mr. Weiss, the defendant's attorney, that they were giving notice to the state that they intended to introduce expert testimony regarding the defendant's mental condition, presumably at the time of the offense in 2022. Of course, this caused concern for the state for many reasons, primarily the timeliness and the violation of Rule 12.2b in terms of notice of a defendant's mental condition. The state asked for a phone conversation with all parties on Friday based on that concern and, quite frankly, just confusion, as this had not ever come up in any type of hearing or discovery or meeting with the parties. It is significant to note that Mr. Moyle and I, General Moyle and I, have met with Ms. Morris and Mr. Weiss multiple times throughout the last several months to exchange even undiscoverable evidence. The state has gone out of its way to provide demonstrable exhibits, PowerPoints. We allowed them to look through our own box account. We've had several met them at the police department to review evidence. Never has an expert witness been mentioned. And the defendant's notice did not provide any information as to what mental condition was being alleged or asserted by their expert. The court then ordered informally on that phone call that the defendant basically turn over what was in their possession in regards to the mental condition and any information about the expert. Mind you, the name of the expert was not listed in the notice that was filed at 2:15 on a snow day. And on Friday, later in the day, Mr. Weiss did send a email to General Moyle and I with the expert's name and his curriculum vitae. And I believe in that email, it was also notice. It was a letter that signified that while the expert was not licensed as a psychologist in the state of Tennessee, he had received temporary licensing for January the 7th, 2025. That letter was written by the state of Tennessee, 2024. It was not until approximately 5:30 on Saturday that the state received what is entitled memorandum pertaining to expert testimony. In that memorandum, the psychologist kindly explains and articulates the law to this criminal court, of which 4 attorneys involved in this case and a criminal court judge are acutely aware. And there's one paragraph in that expert's that alleged expert's report that has to do with Jason Chen. There is one sentence in that report that states that Mr. Chen was not able that Mr. Chen was unlikely to have possessed the requisite premeditation for the act of criminal homicide. The memorandum never mentions a mental condition. As it stands right this second, the day of trial, the state has no idea what mental condition the defendant is alleging he had on November 23rd, 2022. We don't know if it's an intellectual disability based on the tests that were apparently administered to the defendant, which are attached to the expert's memorandum. Based on those, it would indicate it was some type of intellectual disability, as those are psychological examinations that go to reasoning and critical thinking. We have no idea if it's a mental health disorder such as schizophrenia or bipolar. We had heard on the phone call with Your Honor the words voluntary intoxication. Voluntary intoxication, the word intoxication, the word substance abuse, the word addiction is never in the alleged expert's memorandum. This is the epitome of unfairness, Judge. The state has the right to present rebuttal proof. It's one of the reasons why Rule 12.2 has a timing subsection to it. There is no way, it is not virtually impossible, it is absolutely impossible that the state ever could have searched for or investigated any type of rebuttal proof for an expert that we not only knew, well, we didn't know of, but we still, as of 9:30 on January 13th, have no idea what the expert is going to allege or opine at trial. We were not able to voir dire jurors on whatever mental condition this expert is going to allege existed on November 23rd, 2022. In fact, if the jury was sitting in the box right now for voir dire, we would have no idea what to voir dire the jury on. We have the right to a fair voir dire. We would have, in fact, asked questions that pertained to some mental disorder, mental condition, mental health issue. I have no idea. Intellectual disability. No clue. We would have, in fact, voir dired on that issue. It would have changed the process of voir dire for us. It would have changed the preparation for trial for the state of Tennessee. Had we known that there was any type of expert witness that has to do with psychology or the defendant's mental condition, we would have an expert witness sitting in the audience right now to hear what this expert has to say if the court allows the expert to testify this morning in any type of deposition or hearing. We would have them here. We weren't able to do that for obvious reasons. We learned the expert's name at the end of the day on Friday the 10th. Saturday and Sunday are not working business days. While the state of Tennessee worked all weekend, a psychologist or psychiatrist in Chattanooga, we couldn't get a hold of them. And while no party in this courthouse should ever underestimate the capabilities of the state of Tennessee, we are not magicians. We can't just come up with a rebuttal expert witness on a mental condition that we are unaware of at 9:30 on January the 13th. This notice was untimely. This notice never would have been able to happen in any other case in Your Honor's court except for a sequestered case done in the manner in which it was done in this case. Your Honor knows, typically, in all of the trials that the court has not only had as a criminal court trial judge, but also as a prosecutor and defense attorney, normally we move straight from jury selection into the state's case in chief. Typically, this would never have even been able to happen, much less allowed. It is in a rare circumstance that Mr. Weiss could have planned to know of an expert in early December. We know that they knew of him on December 7th because based on an email that they sent to us, it states that he confirmed his availability to meet with the defendant on December 7th. 1 month before he met with the defendant in the Davidson County Jail. They waited. They waited. They knew the week before jury selection that he was going to interview the defendant in the Davidson County Jail. They knew that he had interviewed the defendant in the Davidson County Jail on the 7th. They were in court with Your Honor on the 8th and the 9th. The court repeatedly asked the parties, is there anything that needs to be taken up? Repeatedly. At the end of the day on the 9th. But it was not until 2:15 on January the 10th, after 2 years of preparation on this case, that the defense came up with a mental condition defense. And the defense has argued that it was only after the state provided a demonstrable exhibit to them that they realized that they needed an expert witness that had to do with the defendant's mental condition that affected his ability to form premeditation. Think about this, Judge. Premeditation has been an element in this case since 2022. The Hamilton County Grand Jury indicted Mr. Chen for first-degree premeditated murder. If defense attorneys believed that his mental condition at the time affected his ability to form premeditation, and they waited until January 7th to have an expert evaluate him, then we've got much bigger problems than a timeliness issue. Premeditation has been the case. It has been an element in this case since 2022. And notably, Mr. Weiss represented Mr. Chen in 2022. There has been no counsel substituted. It has been Mr. Weiss since the beginning. The demonstrative exhibit that the defense has such a problem with, as the court has already seen, involves 2 pieces of evidence that have been in the defendant's possession for almost 2 years. A photo from Mr. Chen's apartment of carpet with blood on it, and a photo of Jasmine Pace from the medical examiner's office. The court found in the hearing on this issue that even the state could have superimposed this piece of evidence on this piece of evidence to come up with the demonstrative exhibit. How can a demonstrative exhibit that was given to the parties on December 11th, the day that it was given to the state, even though every party had both photos, but the superimposed photo was given on December the 11th. How is it that that photo affected premeditation in so much as the defense all of a sudden, near or around December 7th, contacted an expert witness? It is untimely. It is unfair. And the state of Tennessee has a right to a fair trial. And the people of the state of Tennessee have the right to a fair trial. We ask the court to exclude any expert testimony at this point in time that was presented to the court and to the state in an untimely fashion, especially that of Mr. Douglas Lewis.
Motion forwarded by Mr. Weiss's pleadings. He mentioned that the demonstrative exhibit seems to indicate that the victim might have been handcuffed in Mr. Chen's apartment. And that's one thing I think he mentions is the problem with the demonstrative exhibit. Could you respond to that?
Sure. Your Honor, the medical examiner issued an autopsy report. The date of examination is 12/1/2022. The autopsy report was given to the parties just within a month or two. Of course, it takes the medical examiner a month or two to finalize an autopsy report. And in that autopsy report, there's a sentence that says, the injury locations are consistent with the decedent's fetal body positioning as found.
They cannot say for sure that the victim's handcuffed while alive in the apartment. I heard you right. The medical examiner's report indicates that the blows might have been received also from fetal position, but not necessarily handcuffed. Is that correct?
I believe that Dr. Cogswell can opine in what position she would have been in when the injuries occurred, and then the jury can therefore, as the trier of fact, make their own conclusions as to the position of her body was only in the fetal position with those type of stab wounds because she had been handcuffed. So the trier of fact can draw their own conclusions, but furthermore, Your Honor, there was a bond hearing in this case in General Sessions Court in which Mr. Weiss represented Mr. Chen, and similar to the autopsy report, Dr. Cogswell testifies the injuries and the concentration are all on the right side. Virtually all of them can be inflicted with her in that bound position. So I believe that there is evidence in the record that would allow Dr. Cogswell to testify that she was in the fetal position. Whether or not he is going to testify that she was, in fact, in those handcuffs, that is for cross-examination. You can obviously cross-examine. That is part of the trial experience. So the defense did have information and evidence and discovery for years that would have indicated that she was in the fetal position. She was in that fetal position because she'd been handcuffed, and the jury, as a trier of fact, can find that.
Good morning, John. Let's be clear. Rule 12.2B2 says timing. Notice described in 12.2B1 shall be filed within the time provided for filing of pretrial motions or at such later time as the court may direct. The timing to file pretrial motions has not ended. As of right now, without a jury sworn, I could file a pretrial motion right here, right now. This rule does not limit my ability to file a notice right here, right now. This court, and I say this with the utmost respect, could have ordered a scheduling order or a docketing order requiring the parties to have presented certain proofs, certain discoveries, certain evidence, certain motions at this point. The court has never ordered that. The defense is not in violation of the Tennessee Rules of Criminal Procedure, and the defense is in violation of any of the court's orders. So this is not untimely. It is timely. Secondly, Dr. Lewis was contacted about a month ago due to timing of the holidays and him getting authorized to practice psychology here in Tennessee. He was not able to evaluate Jason until January the 7th in Nashville. We weren't able to speak to him about his results. He had to review his results, go over everything, and we didn't get those results until late on January the 8th. As soon as we had those results and we knew that we were going to call him as a witness, that's when we filed the motion on the 9th. And even though the courts were closed, it was obvious that all the parties were aware of it. The General Wamp texted, all the attorneys texted the court. We had a conversation about it. And the court has ordered that Dr. Lewis submit a memorandum or report, which he did on Saturday. And I don't know what document the state is reading, but the memorandum in the submitted by Dr. Lewis talks about the psychological issue. diminished capacity. It's right there. We're not alleging that Jason was insane. The state did request a notice for the insanity defense. We're not pleading insanity. So that has no bearing here. We're not saying that he has some type of mental condition. He's not have any type of mental health condition other than what's stated in here. So it is very
jury's
clear
been
the state has
selected,
exact
Rosebud.
notice of what's being alleged by Dr. Lewis. And even
No,
if they
what we can do, we can hold on, let me pull up my chat. We can do a quick recap, or it probably won't be that quick, of exactly what happened. Let me pull out my AirPod. Sorry, y'all, my house is a wreck, so I'm trying to do this and do that. I got to get it all done. I've got to. Let's see. But I didn't want to miss this. So the jury's been, it has been selected, but they had to, like the jury in this case is going to be sequestered. They had to go to Nashville to get the jury because this took place in Chattanooga. And it was so well known that they couldn't get a biased jury from where it happened. So we can definitely go over what happened. It's basically, a college student killed his girlfriend and allegedly. And I don't know. I thought his plea was I thought he pleaded not guilty, but sounds like they're trying to put some mental stuff in there.
They don't. Dr. Lewis has been ordered to be deposed this morning. He is ready and waiting in the virtual waiting room for the court to admit his testimony. And finally, I find it rich that the state says this is untimely. This court, again, didn't file a scheduling order. That means Rule 16 discovery applies up until the day of. I was given a video from Walgreens that I had never seen before. And when did I receive this video from the state? January 9th.
Oh, they're getting no more time.
I'm sorry, January the 8th. The state has provided discovery, monumental amount of important discovery in the last 45 days. At no point did this defense seek a continuance for providing this discovery. The state hasn't sought, or the defense hasn't sought to exclude the discovery based on Rule 16 violations because there isn't one. There isn't a court order. It really wasn't until the defense met with the state and we saw the theme and theory of their case. The state is asking you to read between the lines of an autopsy report. But General Moyle said at the last hearing and in his own response to this notice that they are going to allege that Jasmine was shackled while alive and then killed. That is nowhere contained in any discovery, any evidence. We are surprised. We are being ambushed with this same information. And once it came to the realization that they're providing this information to prove their theme, well, then it became necessary to show that Jason doesn't have or has a condition that would prevent it or negated premeditation. And that's what Dr. Lewis's testimony is all about. There is nothing preventing him from testifying at trial. The state is not prejudiced. They'll have full opportunity to depose him. They'll have a full opportunity to voir dire him during trial, and they'll have a full opportunity to cross-examine him during the course of the trial. It's not unfair, and we ask that the court deny their motion to exclude Dr. Lewis. Of course, Judge.
The Walgreens video that you provided recently, in any way unfairly prejudicial to your patients to the degree that you're asking for consent?
No.
practicing that a lot of work does get done as it builds up the trial. So therefore, a lot of things have to happen. As long as everyone communicates, I've never had it be a problem. I don't even know if it's a problem today. We're certainly discussing it. But while 12.2, as everyone knows, doesn't necessarily put a specific timeline on it except before trial. This is something that apparently the advisory committees looked at a lot in the notes. It's in the case law, it repeatedly refers to unfair surprise, but the state is unfairly surprised. So apparently it's a common practice or common occurrence, I should say, that a lot of times these experts are brought up at the last part of the trial prep. So that's why.
Yeah, want me to do I can do a quick rundown of what happened,
Case,
or I can show one. I can't do one.
You ask for
Let's see.
funds for the expert in.
This will be good. Yes, like they do with all of them, Rosebud. Let's see. Where did I just say it?
The next motion is defense law motions that Jasmine Pace not be referred to as a victim throughout the course of proceedings throughout the trial, and that she be referred to either by name or by proceedings. The state has produced case law that says that it's basically judicial discretion. There's 2 or 3 cases I found on it where the Court of Criminal Appeals found the trial court did not use its discretion by refusing to refer.
I don't know what I've hit that.
The decedent, or whatever you want to call, as the victim. So there is nothing more than just asking this court.
It's playing the same exact thing that I was playing, so I don't.
To use your discretion, and we ask the court that this case would be referred to as Jasmine Pace or the decedent.
This is, if I understand the case law, is that the problems come when there's a dispute on whether or not the victim was actually the victim.
Rosebud, I think you are.
Whether it was simply an accident. I don't think the defense is arguing that a murder did not occur. So I do think that in this particular case, based on what the case law I've read indicates, the issue that prevents a person, or that should prevent a decedent being referred to as a victim, isn't present in this case. The state want to be heard on that? Or?
Your Honor, to the extent that the state would refer to Ms. Jasmine Pace as a victim, that's a theory of the state's case. We submit also that the jury would be instructed following such comments at the conclusion of all of the proof before they are charged to begin deliberation that comments and statements of counsel are not evidence, that they are trials of fact, and that they are the ones to decide whether the defendant is guilty of the crime of murder.
All right, anything else to add, Mr. Weiss, on this motion? Motion overruled.
The next motion was the law enforcement with Hampton County and
I get it, Pammy.
Millersville Police Department executed a search warrant in 1942 Ashland Court in Millersville, Tennessee. During the course of their search, they took pictures of, I believe it's the desk in the bedroom of Jason Chen. And some of those have notes that we believe are protected by attorney-client privilege. And also, we also argue that they are not relevant to the court and they don't have any appropriate value.
Thank you, Dale.
And it's overly prejudicial. And I have those pictures ready to show the court.
State want to be heard?
Your Honor, the state would submit that there are certain portions of the photographs which will be shown here shortly. I also have them printed.
Oh, here.
Yes. Your Honor, I think by the agreement of the parties, we would submit photographs in question with the exception that the state has placed of redactions to material that we think would be objectionable, specifically, I guess, notes that you would describe as possibly statements about conversations with possible counsel, dollar amounts, it looks like. So we would submit this as a collective exhibit for the court's consideration.
I'd like to exhibit one for this hearing.
And in light of the redactions, Your Honor, we would submit that it's not objectionable, it's not unfairly prejudicial.
Yes, sir.
Wow, Rosebud. Oh, man, Patty, thank you.
I can provide these in digital format if the court finds it difficult to read.
You can refer to them if you've got a copy in front of you want to put them on the screen. Just make sure I'm looking at the same posted you are. So we'll do that. Want the defense laptop?
Yes, please. So so this is the unredacted version, which is different than what the court has in front of it. Some of these notes have conversations or notes that we believe that the defendant has written after having conversations with potential counsel, and we believe that's what all these notes are relevant to. So based on that, we would ask for all of the pictures of these notes to be excluded in total. If the court otherwise, in the alternative, we ask the court to go through each note and choose which ones to redact if the court finds it in violation of Rule 403 or if it's protected by attorney-client privilege.
So, General, to understand you, the redacted aspects are aspects that the state agrees should be redacted, or?
Yes, Your Honor, and if we could, I guess, zoom in on, for instance, on, go to 276 Church. Next one, one more. Yes, Judge. So if Your Honor were to draw your attention to the purple note towards the center of the screen.
Yes.
And Josh,
My copy's redacted.
correct. And if Josh,
I'm trying to find a recap.
Your Honor, it's got a phone number there. I recognize that to be a phone number of counsel. I don't know that it would necessarily mean anything to a layperson looking at the evidence, but in abundance of caution, the state did black that out because it was, I guess, indicative of somebody reaching out to an attorney.
I mean, if the state agrees that the blacked out portions should be redacted, we can just talk about the things that Mr. Weiss thinks should be redacted and the state doesn't. I guess we'll go through and post it by post it then.
Yes, sir. The first picture here is, I think, just showing all the notes, and then in the subsequent pictures, you can see individual notes.
Okay.
Here, the one that's labeled right hand.
Saw several last night.
What relevancy this would have to the case? Obviously, it doesn't have any attorney-client privilege information, but it's not relevant.
Here's
Relevance is a pretty low.
Let me see if I can show this and then we can come back. This right here will show a little bit about, not much, but
It was a tense day in court as prosecutors laid out graphic new evidence trying to pursue their case against Jason Chen for the brutal murder of Jasmine Pace.
The victim in this case was a young, vibrant member of our community who had deep roots here.
That victim is 22-year-old Jasmine Pace, the light of her friends and family's lives. Her life was cut short in November when she went missing and was found dead 9 days later.
There's been a lot of interest, speculation, and accusations that have circulated in this community.
Jason Chen is being charged with first-degree murder. The former UTC student apparently had a short relationship with Pace, who family says he met on a dating app. Judge Larry Abels ultimately decided there was enough evidence to bind his case to the grand jury for an indictment. Prosecutors showed pictures of the inside of Chen's North Shore apartment, Pace's last known location. The blue light you're seeing is a reaction to blood spatter. Investigator Zach Crawford testified police determined the blood belonged to Pace.
The proclamation on how much Blue Star reagent would be at least over a liter of fluid. And specifically the Blue Star reagent in this case, I've never seen the amount of Blue Star reagent that I have in this case.
Prosecutors laid out a detailed timeline of Chen's movements the day after Pace was murdered. They showed surveillance video of him in nearby Walmart and Walgreens stores buying cleaning supplies. Crawford said receipts don't tell the full story. They showed purchases of hydrogen peroxide, towels, and asparagus. But Crawford says he bought no vegetables that day and instead bought more cleaning supplies at a self-checkout line.
He did not scan the items at the self-checkout aisle, which is captured on video. He then logs them as asparagus, and those items are further Band-Aids in process as well.
Later that night, Chen is seen here on surveillance video leaving his apartment with what looks like a suitcase. It's about an hour before investigators used his phone records to connect him to the place where Pace was later found dead.
Now remember, she was found in that suitcase. And what he did was he didn't scan certain things. He rang them up as asparagus where it wouldn't show up as cleaning supplies on his Walmart stuff. Right, Penny, right.
Inside of a suitcase. We also got a better idea of the defense Chen's attorneys will present for him. Crawford testified Pace's family had been inside of Chen's apartment after she went missing, but before an official search warrant was executed.
Some items were seized by Katrina Pace and others prior to the search warrant, and some items were seized as a result of the search warrant. Is that correct?
Yes.
Chen's bond will not change. He could be indicted on those first-degree murder charges as quickly as next month. Reporting from the Hamilton County Courthouse, Liam Collins.
See, his mom went into that guy's apartment looking for stuff to try to find her daughter. So that's something they tried to have a lot of stuff thrown out because of that too. So that's why I thought this is gonna. I'm telling you, this is gonna be a good one. Let's see. Hey, knitting. Hey, he's from Chattanooga. If I'd known about it sooner, I definitely could have been there, huh? But so he killed his. I guess it was his ex-girlfriend. They dated for a little while, and if I was committing a crime, I think it would too. I think it would cross my mind. And again, we'll probably never know what happened, why, and all this, but let's see if they're still doing motions. Let's see. Let me find it.
General, whenever you're directing Dr. Cogswell, you cannot say, is this indicative of premeditation? That's something that would have been objectionable to anyway. I'm not saying you would, but just where we are today, based on the defense attorney's assertions that the medical examiner's testimony might be unfairly utilized for him to opine that it was premeditated. Obviously, you can't ask anything about that, correct?
Correct, Your Honor. He's a forensic pathologist.
No, but well, he cut her up, I think.
And so based on those factors, that the state's motion to exclude expert testimony be granted.
Hey, Ginger.
Your Honor, at this time, I would request to do a proffer.
Can y'all hear it okay?
Dr. Lewis answer some questions.
At this point, I'll let you direct the witness.
See if it's turned up all the way over there. Yep. I think they're having audio stuff there. And right now, there's no sound. Rosebud, I think that's what it's going to end up coming down to is all suitcases are going to end up being see-through. Dead air. The counter. See-through suitcases help the victim at the time. No, probably not. Guess it would help if I turned on the volume. Hi, Jennifer. How old is Jason Chen? He's very young because, 2 years ago he was a student at UTC. Maybe 21, 22, 23, something like that. I keep saying Timothy. It's Jason Chen. Jason. And I thought they were doing opening statements, or probably wouldn't have started streaming so quickly.
Good morning, Dr. Lewis. Can you hear us okay?
I can. Good morning.
Hear the comments for the witness for me? Yes, sir.
Raise your right hand, sir. Do you swear or affirm to tell the truth, nothing but the truth, so help you God?
All right, so I think he's going to try to say whether or not, and this is without the jury being in there, because it's motions, he's going to say whether or not he thinks she was handcuffed in that suitcase before or after death. I think this will be good. I'm going to put in my headphones, fold laundry while we listen. Okay, stay where you are.
You let Felix know we got figured out this today.
Good morning, sir. Good morning, sir. Can you hear me?
Yes, I can.
Okay. Can you please state your name?
I am Dr. Douglas E. Lewis Jr.
And Dr. Lewis, what do you do for a living?
I am a forensic psychologist.
What is a forensic psychologist?
A forensic psychologist is a clinical psychologist who uses psychological principles to answer legal issues.
How long have you been doing that?
I have been in practice solo for about 5 years now.
To become a forensic psychologist, do you have to get an education?
Yes.
Can you
So
tell me?
you have to.
Go ahead.
So you have to earn a graduate degree, in particular a doctorate in psychology. And in order to do that, one must have 4 years of didactic instruction, in addition to 3,000 hours, usually minimum, in practicum experiences, which is hands-on experience under supervision. Then one must go through a match process in order to get a pre-doctoral internship, which is a year-long internship, and then you earn the doctorate. Once you earn the doctorate, you must participate in a postdoctoral experience, and that is for at least 1 year, and then you become licensed as a psychologist.
So what schooling did you receive?
So initially, I earned my bachelor's degree from the University of Virginia in mathematics, finance concentration in 2009. And then later, I earned a terminal master's degree of education in clinical mental health counseling from Lynchburg College, which is now referred to as University of Lynchburg, in 2013. And then in 2019, I graduated with a Doctor of Psychology and Clinical Psychology from the Chicago School of Professional Psychology in Washington, D.C. And then later, I completed a postdoctoral fellowship at Emory School of Medicine in the Department of Psychiatry and Law Service in 2020.
And when did you graduate with your doctorate?
I graduated in 2019 with my doctorate.
And you've been in practice now for the last 5 years?
Yes.
And what does your practice,
Approximately.
what does your practice entail?
My practice entails both civil and criminal justice cases. So I conduct competency to stand trial evaluation, criminal responsibility or mental status at the time of the offense evaluation, violence risk assessment, psychosexual evaluations, independent medical evaluations, workers' comp evaluations, personal injury evaluations. And that's for both juveniles and adults.
Have you ever worked in the prison system before?
Yes. So I began supervised work in the prisons in 2015, and then I became somewhat of the de facto clinical director within a prison in 2021. Not only did I work with housing placements in terms of their psychological status, I also provided treatment in what is considered here in Georgia high max. So those are individuals who have not only committed murder or other heinous crimes outside of the prison, but also those of which you have done the same thing within the carceral environment.
Have you ever testified in a court before?
I have.
How many times?
I would say approximately 10 times. I've testified in court.
Is it just criminal cases, or do you do both criminal and civil?
It has been criminal and civil.
In the criminal cases that you have participated in, have you always represented a defendant?
No, I have not. I have been on the prosecution side before. I think the last time I was on the prosecution side was probably in 2022 or 2023.
Are you licensed in Georgia?
I am.
Are you licensed in Tennessee?
I am not licensed in Tennessee. What I got was a temporary authorization to practice psychology through the board in Tennessee.
Thank you, Dr. Lewis. I want to talk a little bit specifically more about this case involving Jason Chen. Do you remember when my
Would you like the witness recognized as an expert?
yes, sir. At this time, the defense moves to proffer Dr. Douglas E. Lewis as an expert in forensic psychology.
State one of audience witness.
Your Honor, this is, as a proffer, the state doesn't have a right to cross-examination. So if this is just simply a proffer,
I'm proceeding if you want to even have him qualified as an expert.
sure, the state would like to call your the witness. Dr. Lewis, you said that you got your doctor of psychology in 2019, is that correct?
That is correct.
But you were not licensed as a psychologist until 2021, is that correct?
That is incorrect. I was licensed in August 2020.
Okay, August 2020. And then in Virginia, it was August of 2021, is that correct?
That is correct.
All right, so licensed as a psychologist, and your degree is in clinical psychology, which is different than forensic psychology, correct?
It is the generalist form, but forensic psychology is a specialty. One must be a clinical psychologist in order to be a forensic psychologist.
So I'm sorry. Did you get a degree in forensic psychology or clinical psychology?
No such degree exists. You cannot get a doctorate in forensic psychology and practice as a forensic psychologist. You must be a clinical psychologist first, and then you must specialize in forensic psychology.
I understand. Okay. And you stated that the Chicago School of Professional Psychology is in Washington, D.C., is that correct?
Yes, I was at the Washington, D.C. campus.
You went to school physically in Washington, D.C.?
No, I did not. So essentially what happened was I earned my degree, or I matriculated at the Georgia School of Professional Psychology in Atlanta, Georgia. While I was on predoctoral internship at the Superior Court of the District of Columbia, unfortunately, the school abruptly closed while I was on predoctoral internship. And so what happened was the American Psychological Association, in addition to the Department of Education, moved those of us who were affected by the school's abrupt closure to the Chicago School of Professional Psychology in Washington, D.C. So essentially, it was somewhat of a pro forma or formality in terms of a teach-out agreement that was reached by the Department of Education and the American Psychological Association in 2019.
You went to online school?
No, sir. Excuse me. No, ma'am. You cannot go to online school and graduate and get a license in Georgia. You must go in person. I went in person for 4 years to get my didactic instruction, and then I matched to my first choice at the Superior Court of the District of Columbia.
But on your resume, it states from 2015 to 2019, you were a psychometrist in Atlanta, Georgia.
I was. I went to school in Atlanta, Georgia, ma'am.
But your resume says that you went to the Chicago School of Professional Psychology in Washington, D.C.
Okay, so let me explain again.
I'm sorry, I'm confused. Yeah, I'm very confused.
I know, I want to help you if you allow me to, ma'am. So I matriculated at the Georgia School of Professional Psychology which was located in Atlanta, Georgia. While going to school in person, because I come from humble beginnings, I also had to work. So I worked as a psychometrist alongside with getting my doctorate from the Georgia School of Professional Psychology. Part of the training in psychology is this. You must go to school for 4 years and receive didactic instruction and practical experiences. Then you must match.
I ain't gonna lie, he's kind of got me lost too.
For American Psychological Association accredited internship. I matched at my first choice, which was the Superior Court of the District of Columbia. While I was on pre-doctoral internship, which is a year-long working supervised experience, my school, the Georgia School of Professional Psychology, abruptly closed around March the 8th of 2019. The Department of Education and the American Psychological Association, understanding that we were about to graduate and the school closed, did what is called a teach-out agreement. The teach-out agreement was with the Chicago School of Professional Psychology, the Washington, D.C. campus. And that is where I graduated from.
Okay. Your resume states that you are an adjunct assistant professor at Emory University. So the year that you received your licensing, you also became an adjunct assistant professor at Emory.
Yes.
And your LinkedIn says that you've been an adjunct assistant professor from September 2021 into present. So which one is correct?
What is correct is what's on my CV. So what happened was I graduated from the postdoctoral fellowship program in 2020. As soon as I graduated, because of my work, they wanted me to stay on to teach others. And so 2020 would be the correct date.
So September 2021 on your LinkedIn is not accurate.
If it says September 2021 on my LinkedIn, it must not be accurate. Let's go with my CV. That is the most up-to-date and accurate.
Okay. And a lot of your work has been with inmates, correct?
That is correct.
And a majority of your work has been, has involved a defendant's competency to stand trial. Is that correct?
I wouldn't say it's the majority of my work, no. I've done a lot of work with competency to stand trial, and I also was integral in developing a jail-based competency restoration program, and I've also published on competency restoration. But I wouldn't say it's the majority of my work, no.
What is the majority of your work?
The majority of my work just includes the specialty of forensic psychology. So I do civil and criminal work, and it really just depends.
What is the majority of your work?
I wouldn't ascribe anything as being the majority other than the work of forensic psychology. So forensic psychology includes both civil and criminal work, and that is the majority of my work.
Yeah, Rose, but I'm
type of evaluation or type of activity that I would say would be the majority.
Okay.
The specialty is the majority.
Okay, and you testified that you have testified approximately 10 times in both criminal and civil court?
In totality.
10 times, and how many of those times were in criminal court or in a criminal case?
I really don't recall. I would say the majority of them were criminal. I think only 2 of them involved civil, and that was parental fitness / custody type evaluation. So I would say maybe it was definitely the majority of criminal. I probably prepared over 100 reports for the court, and so I would say the majority.
way to go, Rosebud.
Okay, so 8 criminal cases. Of those 8, how many involved a homicide?
Uh-oh.
1.
Okay, and what did your testimony involve in that case?
I don't know if I can get into the specifics of that, but what I will say is that I was retained by the defense on that case.
Was your testimony regarding the defendant's competency to stand trial?
Oh, no. My testimony was regarding mitigation for sentencing.
So you testified at a sentencing hearing?
Yes,
And you understand that there's a difference between testifying and being tendered as an expert witness and qualified by a court as an expert witness, correct?
Yeah, Dale, it's not looking good for
when
him.
I testified for this particular case, I was for here.
How many times have you been qualified by a court as an expert witness?
I would say approximately 10 times.
Where,
Each time that I testified, I had to be for here on both sides.
I'm not asking about what year, I'm asking about tendered and qualified as an expert witness in a case. Qualified as an expert witness.
If I'm understanding it correctly, approximately 10 times.
Okay, but he's saying 10 times. I don't think he's
You
understanding.
testified that you often do evaluations on mental state at the time of the offense.
Yeah, so it's called different things based on the state. So in Georgia, it would be called criminal responsibility. In Virginia, it would be called an insanity evaluation. So I just generally said, but both of them are the same in that it is assessing or evaluating one's mental status at their time of the offense.
You believe that insanity is the same as mental culpability?
No, I don't think I said that, ma'am. What I was saying is that the statute is named differently based on the state. So some would call them mental status at the time of the offense. Georgia, for example, calls it criminal responsibility, and Virginia would call it insanity. But it's state dependent, and the state determines what the legal standing is for that.
Okay. On your resume, there's a section entitled Adult-Clinical. And it states that in 2011 and 2012, you were, it doesn't say what your position was, it just says adult psychiatry / co-occurring disorders inpatient at Virginia Baptist Hospital.
That is correct.
But in 2011 and 2012, the only degree that you had was in mathematics.
That is correct.
Virginia Baptist Hospital was allowing you to work in a psychiatry department with a mathematics degree?
Yes, ma'am. So in Virginia, there is a title called Qualified Mental Health Professional, or QMHP. And as long as you have a bachelor's degree and you take the continuing education, they will give you a certification called the Qualified Mental Health Professional. And so that is what I became, and that's how I was able to work at Virginia Baptist. I also interned at Virginia Baptist under the supervision of a clinical psychologist while I was earning my terminal master's degree.
Now, he wants to testify for the defense, right? I think so. It was cold, Ginger. Yes.
One moment, Earl. What is a psychometrist?
A psychometrist is essentially an individual who has at least a master's degree, who has been trained to conduct psychological assessments, or which involves administration, interpreting, and scoring. And that individual must be supervised by a psychologist.
And your resume states that you were a psychometrist from 2015 to 2019, is that correct?
Yes.
And this is while
And
you
in
were,
that role,
what?
in that role from 2018 to 2019, I took on I was a reviewing psychometrist, which is a little bit different from actually administering the scores or administering the measures. So from 2015
Hey,
to
Alicia, good
2018, I
morning.
was in person actually administering the psychological test, it's scoring and interpreting and writing reports. From 2018 to 2019 as a psychometrist, they had me review other psychometrist reports for their accuracy and then send them to the psychologist.
Okay. And let's turn to your teaching experience. From 2016 to 2018, you have two separate places in your teaching experience. It says that you were a teaching assistant with the Georgia School of Professional Psychology. What are the differences between those two? Why is that listed twice on your resume?
Because I was a teaching assistant for multiple professors in my graduate program.
And you were also a psychometrist at that time.
Yes, ma'am.
You were also working in Beaufort, Georgia in that time.
That was as an intern, but yes, ma'am.
And you were also in College Park.
Yes, ma'am.
He's been busy.
Let's turn towards this case. What were you asked to do in the case of State versus Jason Chen?
I was asked to assess or evaluate the issue of premeditation.
When were you asked to do that?
December the 10th is when I was asked to do that, of 2024.
When was your first communication with defense counsel in this case?
It was late evening, December 7th of 2024.
And you said that you were asked about premeditation. What does that mean?
Premeditation as defined by the state of Tennessee.
As it relates to Jason Chen?
Yes.
What is the offense date in this case?
I don't recall the exact offense date. I do recall that it was in 2022.
Okay.
I believe it was November of 2022.
And were you asked to evaluate the defendant for mental condition?
Yes, I suppose that was a part of it, yes.
What were the other parts of it?
Well, the only thing that I was asked is about the issue of premeditation. But of course, if I'm conducting a psychological evaluation, there is a possibility that a mental condition could emerge or be revealed. But my understanding, my understanding was that that individual had never had any mental conditions. But part of a psychological evaluation, such could be revealed.
Did you decide that Mr. Chen has a mental condition?
I did not give Mr. Chen a formal diagnosis. However, Mr. Chen does have some, what I would call some mental health or psychiatric challenges, to include depression and anxiety.
Dr. Lewis, I'm sorry to interrupt. The technical transmission of what you said a moment ago didn't completely come through. I think I understand what you said, to make sure you say you did not give him a formal diagnosis.
That is correct. So I did not give Mr. Chen a formal diagnosis. However, I do know that he has some psychiatric or mental health challenges.
How do you know that?
Depression and anxiety. based on psychological testing, based on my interview with him, and my observations of him.
When you say psychological testing, are you referring to the tests that are mentioned at the end of your memorandum?
Yes, ma'am.
And are you aware of how long Mr. Chen's been in the Hamilton County Jail?
Approximately since his arrest, I would say approximately 2.5 years.
And are you able to opine as to when he developed this depression and anxiety?
Good question.
My opinion is that he developed it during childhood.
Wow.
So I'm assuming that you had reviewed his medical records from childhood forward.
I reviewed what was in the discovery, and in the discovery, I did not see any medical records.
I'm assuming that you
from
interviewed
Mr. Chen.
his parents to learn more about his childhood.
I reviewed the statements that were in the discovery from his parents, particularly his mother. But other than that, no, I did not interview his parents.
The statements from his mother that included that he did not have a mental condition?
Right, Dale.
Yes. I saw that in the discovery, multiple times individuals indicated that he did not have a mental condition. I disagree.
Because Jason told you that he did.
No, he actually did not. He said he doesn't have any problems either.
So what did you rely on? You had no medical records. You did not interview his mother and father when it comes to childhood issues. The defendant denies having any kind of mental condition. What did you rely on?
I relied on my years of experience since 2010 of working in the mental health field across jurisdictions. I also relied upon my review of the discovery, all the documentation that was in there. I relied upon my interview with Mr. Chen, which involved many questions, to include questions that are diagnostic, questions that deal with violence risk, questions that are about his sexual history. I also relied upon objective testing, psychological testing that is peer reviewed, and all the other things that were in discovery. And that is what I relied upon, which is best practices in terms of the field of forensic psychology. It was a
Hey, Warrior Grandma.
approach.
You've only spent 3.5 hours with Mr. Chen.
Approximately 3.75 hours.
Oh,
yes.
I apologize. You've only spent 3.75 hours with Mr. Chen in Mr. Chen's entire life.
That is correct.
And that was last week.
January the 2nd.
And you administered 3 tests during that 3.75 hours?
Yes, and that took him about 50 minutes or so to do, the 3 tests.
50 minutes. He did 3 tests in 50 minutes?
Yes, one of them, you have to finish within 16 minutes for it, because it cuts off. So one of them was time.
So, and then the rest of the 3 hours, you just simply asked him questions about his mental condition that he doesn't have?
No, I asked him questions basically about his life from birth to present. So those questions are across the board. Some of which of the questions you don't really know, or the individual of the examinee really doesn't know why I'm asking the questions that I'm asking. They're not face valid. So the questioning is not just about a mental condition.
You based your opinion that it's highly unlikely that Mr. Chen could form premeditation in 2022 based on 3.75 hours with Mr. Chen.
Hey,
50
Serendipity, good to
minutes of
see you.
those consisted of him taking 3 tests to help you decide this issue.
And also over 14 years of experience of working with justice-involved persons.
Mm-mm.
And one of those cases in 14 years involved a homicide.
Oh, I didn't read all that. I'm so sorry you've been sick. I'm glad you're better.
But I've done many murder cases that I've written for. Usually the court stipulates to my reports. So I don't testify a lot.
Well,
for
but your
that reason.
reports
But
don't
I-
have to, your reports don't have to do with premeditation at the time of the offense.
But they have to do with murder, which is what you asked, I thought.
Okay. None of your reports have had to do with premeditation at the time of the offense.
No.
And in your memorandum to the court, did you mention depression or anxiety?
I don't believe that I did say that. I don't believe I said that explicitly. However, if you look at the end where the tables of the testing, even a layperson can see that some of the scales are elevated regarding depression and anxiety. But no, I don't think I explicitly indicated that in the memorandum.
Have you ever been in jail, Dr. Lewis?
As a professional, yes, I've been in many jails and prisons.
Of the people that you've worked with, how many of them experienced depression and anxiety?
Probably
Right.
most of them.
You stated in your memorandum that you relied on a handful of articles or websites, in one case, a book, to form your conclusion in the case of Jason Chen. Is that correct?
Relied on is probably not the right language. I would say that those items, in addition to all the other methods, is how I form my opinion. So essentially, I provided those for individuals who are not versed in mental health or forensic psychology, etc. But yes, those were a part of forming my opinion because it gives foundation of knowledge for those who are not privy or not in this area.
Sure. Your report says, and a review of pertinent research, and then it cites to footnotes 5 through 15. Is that correct?
That's right, ma'am.
And number 5, the title is Proactive and Reactive Aggression, a Developmental Perspective. Are you going to opine about Mr. Chen's aggressive behavior?
I intend to educate the court about, some people call it in literature proactive and reactive aggression, and then in some literature it's called affective and predatory aggression or violence. And so what I want to do is educate the court about the difference between affective or reactive aggression versus predatory or proactive aggression.
And what does that have to do with Mr. Chen's mental state on November 23rd, 2022?
Well, what that has to do with it is that in terms of premeditation, typically one shows that they have predatory or proactive violence or aggression. And there are certain items that must be there, or factors or traits that must be there for such. And when in issues that are raised about premeditation where someone's arguing that an individual doesn't have premeditation, then one would look at affective or reactive aggression, because those have certain elements or traits. And so what I would like to do is, what I intend to do is to educate the court on the differences of the two.
You understand in this case you would not be testifying to the court, right?
We're not testifying to the court. I'm saying educating the court about the difference, because the differences of those two items.
Just my opinion. He can't say where it was that it was premeditated or not.
How do those issues relate to diminished capacity?
They don't relate to diminished capacity.
But that's what your finding is from Mr. Chen.
I didn't say anything about diminished capacity. I didn't use those terms. My understanding is that that is not a term that's in Tennessee, but that it is recognized in Tennessee, but I'm not using those terms. What I'm saying about Mr. Chen has to do with affective or reactive aggression, as well as the impact of substance use. However, I'm not explicitly using those terms or that term.
So what is your finding as to Jason Chen's mental condition on November 23rd, 2022?
My finding is that Jason Chen likely displayed affective aggression while also under the influence of substances.
And what evidence or information do you have that Mr. Chen was under any type of influence of substances on November 23rd, 2022?
In terms of evidence, the only thing that I have is that his report that he was using substances, and also but by my question of him, many of which were not face valid at all, it appears that he has been using substance for many years.
You'd agree that using substances for many years doesn't mean that you were intoxicated on November 23rd, 2022, right?
I do agree with that. However, in my work with substance users and individuals that are just as involved, people just don't stop using substances.
So you are going to testify that Mr. Chen was under the influence of a substance on November 23rd, 2022 because Mr. Chen said he was?
I'm not going to testify directly in that way. What I'm testifying to is that he reported that he was under the use of substances. And the psychological testing suggests that he does have issues with drugs.
So you can't.
I'm not directly reporting that. I'm reporting that that's what he informed me of. And based on his psychological testing, it suggests that he does have issues or challenges with drug use.
Well, you said you've gone through discovery in this case, correct?
Yeah.
When did you receive discovery in this case?
It had to have been the week of December 17th, because it wasn't until December 17th that the Tennessee board allowed me to have temporary authorization to conduct the evaluation.
So, homicide cases involve an extreme amount of evidence, correct?
Lacey.
Yes, they do.
And between December 17th and January 7th, would you say that you went through all of the discovery that was delivered to you by the defense attorney?
Between then and January 7th, I would say no. I went through most of it. And since that time, I haven't gone through all of it.
What did they deliver to you?
There were pleadings, there were mitigation documents, there were police reports, there was a medical examiner's report, there were pictures of the deceased. There were pictures of Mr. Chen and his family. There was a transcript of his bond hearing back in 2022. There was a lot.
And what in that discovery indicated that Mr. Chen was under the influence of a substance on November 23rd, 2022?
I don't believe anything explicitly indicated that.
And what was that substance?
He reported that he and the deceased drank an entire bottle of wine, and after they drank an entire bottle of wine, they smoked joints or marijuana, and then they also had wax, which is concentrated THC.
But you'd agree based on the autopsy report that there's evidence to the contrary of that, correct?
Objection to argument.
I think the question was specifically to
You'd agree that based on the autopsy report, there's evidence to the contrary, is that correct, Dr. Lewis?
I would agree, but I think that the question you're asking is a bit misleading, given when the body was found and given how the testing was done. Apparently, based on what I saw, it looked like the testing was stopped for some reason. And then also because there had been some time that had passed, and the way that any type of drug enters your body, there's a time where it has a half-life. So it starts to diminish or denature. So I don't think that is I don't think that is a clear question. I would say that yes, the medical examiner said that there was nothing found in terms of substance use, but I don't think I think that question is a bit misleading.
And Dr. Lewis, you don't have a degree in forensic pathology, do you?
I don't, but I know what I've read.
And you don't have a degree in pharmacology, do you?
I don't. However, when you are trying to do clinical, you do have to take psychopharmacology. So I had to learn about pharmacokinetics in terms of medication.
And you can't, as a psychologist, prescribe medication, can you?
I cannot, but psychologists do. They do additional
Okay,
training.
well, I'm not concerned about other psychologists. You can't prescribe medication, can you, sir?
That is correct.
And, your basis of knowledge pertaining to marijuana, based on your memorandum, is, one of them is from the DEA website?
The DEA website is good information for laypersons, but I have treated and worked with people who have substance use disorders. So again, what was on the memorandum was for people like you and others who are not trained in working with substance use disorders or psychopathology, and that was for a reference that would be easy for you all to understand. However, I am not solely basing my opinion on the 15 citations that I gave. I'm basing my opinion on years of working with individuals in different jurisdictions who have substance use disorders and also have mental disorders.
But in your memorandum, you'd agree that you referenced these specific articles as what you reviewed to help you form your conclusion in this case.
I said that those articles were useful in forming an opinion. However, they are not the only things that I use. Part of being an expert is that it's the years of working with individuals who have similar or the same types of challenges. So I would not hinge my opinion on just 15 citations. It's more so to allow the reader to understand what it is that I'm talking about. So I don't want to be misleading and have you think that only 15 citations, one of which was a DEA website, is how I came up with my opinion. It's actually my years of training and in practice with individuals.
And which of these articles have to do with a defendant's mental state at the time of an offense?
None of them.
Which you'd agree is what you would be testifying on, correct?
Yeah.
Okay, and, your resume has a lengthy list of, publications that you, along with others, have published over the years. The last publication being in 2022.
Yes, ma'am.
And
And I
can
think
you-
that publication was republished by the NIH, or the National Institute of Health, in 2023.
That's great. Okay, yeah, that one was, the need, the controversy, the impact of COVID-19, right?
Yes, ma'am.
Okay, and then can you point to which of these publications has to do with a defendant's mental state at the time of an offense?
None of them.
Oral presentations, you cite 21 oral presentations, several of which you would agree included yourself and other presenters, correct?
Yes, ma'am.
In which of these presentations that you gave relate to the defendant's mental state at the time of an offense?
None of them.
How many times have you testified to a defendant's mental state at the time of an offense?
Once on the side of the prosecution.
And in that case, did you interview the defendant?
Yes,
For how long?
about an hour.
How far was that interview from the time of the offense? How long after?
I would say approximately maybe like 10 or 11 months after.
And what was your opinion in that case?
My opinion was that he was sane or he knew what he was doing. So I was on the side of the prosecution.
So that had to do with sanity, is that correct?
Well, in the state of Georgia, it's called criminal responsibility. So I found that he was criminally responsible.
You just said sane. So is it sanity or criminal responsibility?
It's criminal responsibility. The case was in Georgia.
What type of homicide was that?
It was not a homicide. It was an aggravated assault.
So you've never testified or opined regarding a defendant's ability to form premeditation in a homicide case.
I've written reports that I have opined that they were criminally responsible of a homicide. But I've never testified. But I have written reports in murder cases where I found them criminally responsible for the murder.
A report for what? I don't understand. For
Okay,
sentencing?
No. So there's two types of reports that are common in courts. One type is called competency to stand trial. And the other type is called, based on the state, it would be either criminal responsibility or insanity evaluation. Those reports, those types of evaluations are ordered more than any other type of evaluation. And so often I would perform a competency to stand trial evaluation as well as a criminal responsibility evaluation. So these things happen pre-adjudication. They're not sentencing or mitigation.
This is not looking good on him.
Okay, so the competency to stand trial evaluation typically go to the court. Now, the criminal responsibility evaluations go to the defense typically, because that's usually more of an ex parte issue. And when it comes to sanity or criminal responsibility, essentially people see it as a legal strategy at times, because it depends on how the
I think she caught him in a lie.
attorney wants to work through the case. So those types of reports only go to the defense attorney typically, because the individual is admitting that they committed the crime, and I'm evaluating their thoughts or actions or behaviors before the crime, during the crime, and after the crime. And for that reason, typically those reports do not go to anyone but the defense attorney, who decides how they want to work the case.
They're never intended to be introduced in a trial or in a hearing for the defendant's guilt, right?
I can't say that because I'm not an attorney. I'm not sure how they use it afterwards.
Well, where is that report in this case?
Pardon me?
Where is that report in this case?
Those type of reports are ordered by the actual judge. So if it's not ordered by the judge, then there is no report. I was retained by the defense, and when the defense or the prosecution, whoever retains me, they ask a question, and I'm the one who is evaluating the question that they're posing. But those type of reports are typically ordered by a judge.
What was the question in this case?
The question in this case was to again evaluate or assess the issue of premeditation.
That's not a question. What was the question in this case?
That was the question.
To evaluate
I'm
premeditation is not a
I'm
question.
sure. Okay. Determine whether or not Mr. Chen had premeditation in this particular case. I'm not sure how you want me to word it.
Okay.
That's what I was asked to evaluate.
Okay. Let's go to the test that you administered in the 50-minute time period you met with Mr. Chen in the Davidson County Jail. TOGRA is intended to measure reasoning and
What a waste of time.
correct?
Yes, ma'am.
And Mr. Chen, with a 94, was within the standard deviation, correct?
Yes, ma'am.
And you'd agree that school records probably also could indicate someone's level of reasoning and critical thinking, is that right?
They could. However, there can be a little bit of politics when it comes to school records, like individual education programs or 504 plans. Sometimes individuals can be labeled or mislabeled, depending on their behaviors in school. And so I would not use school records as the only statement in making an opinion.
So did you
Particularly
review,
when I work-
did you review Mr. Chen's college transcripts?
No, I did not.
Are you aware that he had a scholarship to the University of Tennessee at Chattanooga?
Yes, and I actually asked how did that happen, given some of the information that I learned about his, some of his own reports about his behavior in school. I was curious about that he did earn a scholarship, but different scholarships have different requirements. So I know that scholarship that I'm aware of, he likely wouldn't have been necessarily a person that would have gotten some of the scholarships I know about. However, yes, he did report that he had a scholarship.
What does reasoning and critical thinking have to do with affective aggression?
Well, I don't think the two are directly related. However, one must have a certain level of reasoning and critical thinking ability to be responsible, knowing, or intelligent. One must have those attributes. So part of the reason why I did that testing was to get an idea of how he's functioning cognitively. And he's functioning in the average range in terms of when compared to other adults. So that's why I gave that test.
Okay, and did this test measure how he was functioning cognitively on November 23rd, 2022?
No, ma'am. However, I will say that.
Right, because how could it?
Cognitive functioning tends to be stable unless something happens like a traumatic brain injury or some type of other injury. Typically, intelligence or functioning is stable, particularly at a certain age group in the lifespan.
I understand. So if he was functioning cognitively in January of 2025, he most likely was functioning cognitively in November of 2022, based on what you just said.
Yes, in the absence of substances, absolutely.
And personality assessment inventory. Which one of these tests takes 16 minutes?
The TOGRA.
And then how long do the other two tests take?
It depends. Some people have gotten it done in 20 or 25 minutes. And then some people have taken hours to do it. It just depends.
How long?
It's basically questions that says it's mostly true, slightly true, false, never. So it's things like that. So the items are short. Like some of the items might say something as short as, I like airplanes. It's not much, you don't have to do, you you don't have to do much thinking. It either is or it isn't. So it depends though. Often people who take a long time are people who are misleading, and they typically invalidate the test because they're thinking too much.
Imagine being this girl's parents having to listen to him say this
So
stuff.
in 50 minutes, you're comfortable with a criminal defendant charged with first-degree premeditated murder taking a test of general reasoning ability called TOGRA, a traumatic symptom inventory, and a personality assessment inventory?
I was with him for longer than 50 minutes.
No, that was my
I said it
question.
took 50. Okay.
Are you comfortable?
Can you rephrase?
Are you comfortable with a defendant taking 3 psychological tests within a 50-minute period that you then relied on?
That was part of a multi-method approach? Yes. I would not rely just on that, no. So I think you already mentioned all the things that I did rely on. But just the testing, no. So it's best practices that you do a multi-method approach. So I would never hinge an opinion just on testing. It's everything, and it's everything that I would do.
Oh boy.
For the trauma symptom inventory, TSI-2, it says that the clinical scales reflect 4 broad categories of distress: self-disturbance, post-traumatic stress, externalization, and somatization.
Somatization, yes.
Can you explain which of those has to do with the defendant's mental state at the time of an offense?
So that particular testing doesn't mark directly to a mental status at the time of the event. What it does is it gives me a profile of how this person is social emotional function. So does this person lash out at others? Do they have anxiety? Do they have depression? Have they experienced trauma in their lives? Are they likely to become easily angry or agitated? So what that does is it's one component of gives me an idea of his personality profile, but it does not. There is not a test that loads directly onto a legal issue. That's not how testing is designed.
Okay. And so the same thing for the personality assessment inventory. That test has nothing to do with the defendant's mental state at the time of a criminal offense, does it?
Not directly, no.
Do any of these have to do with substance disorders?
Yes.
And do they have to do with a defendant's use of a substance 2 years prior to the test being given?
So typically, what it does is ask innocuous questions that essentially recreate a personality profile. While individuals are different, there are certain challenges that people have that are very similar. So what we've developed through the testing is we are developing a personality profile panoramic of how someone is functioning. So no, it does not necessarily is not as specific as you're asking. However, when I talk about likelihood, there's a certain personality profile that is developed by use of the testing and the other sources.
She has got to be so aggravated. Got to be. And Lacey, it's not your AirPods, it's this audio here. I can hear out of my right. I have on my headphones. I hear my right one, not my left one. I keep hearing some weird crackling in my left one. I don't know. Dale, are you still here? I don't think that he's an expert. I don't think he can be qualified as an expert. Maybe though. She don't look too happy.
since you reviewed the discovery in this case, Dr. Lewis, can you describe some of the things that the defendant did after he murdered Jasmine Pace?
He visited a convenience store or.
Objection. I don't know the relevancy regarding his qualifications. I don't know how that question answers. This is what here.
All right, back go.
It seems like it could apply to both, I guess, in the sense that's clearly relevant to his opinion. It may be relevant to his qualifications. He gives great weight to it, not much weight to it. So at this point, feel free to renew your objection otherwise at any time. It gets raised too far.
Okay, continue, Dr. Lewis.
He went to go purchase, cleaning products.
And what else?
He also moved the victim's, vehicle. He used the cleaning products to clean up his apartment.
And what else?
He left the apartment, I believe, to stay with his parents.
And what else?
I'm not sure what else you're asking.
How much weight do you give to what a defendant does after a murder when it comes to premeditation?
When it comes to premeditation, I give it great weight. I find those details, quite frankly, to be aggravating.
What do you mean?
What I mean is that essentially, if those things, or if those actions are the actions he took, then it appears that he attempted to hide or cover up whatever act that he committed. So I take great weight to that. I found that aggravating. However, I do not find that it is suggestive of premeditation. Quite frankly, I find it to be the opposite in terms of the individuals that I work with inside the carceral environment. If they engage in forethought or planning, they typically would not do the actions in the way that it was reported that Mr. Chen did. It doesn't fit the profile of someone who engaged in forethought and planning.
But in Tennessee, premeditation doesn't require planning, right, Dr. Lewis?
And based on what I read in terms of premeditation, it means that you have to have some type of forethought before the action is done.
You'd agree that somebody who is under the influence of a substance would have, how would you say it? Well, a difficulty completing tasks that a sober person may be able to complete, correct?
They probably wouldn't be able to do it in the exact same way. But someone who's been doing substances for quite some time, they may be able to function a little bit better than someone who perhaps is just starting stuff.
So if Mr. Chen was a regular marijuana user, he probably could have functioned a lot better if he was under the influence of that substance?
He may have been able to. However, he also said that he used wax, which wax is a much greater concentration of marijuana or THC.
Do you take into consideration when forming your opinion that criminal defendants will most likely say whatever they need to say instead of going to prison for the rest of their life?
Absolutely.
How is that factored into your decision here?
I didn't give great weight to it. It's part of the decision, but I didn't give great weight to the use of the substance. I gave more weight to the personality profile type that he fits into, more so than the use of a substance. He did report that he used a substance. The testing shows that he's likely a substance abuser. However, that is not something that I gave great weight to.
You did not give great weight to the use of a substance.
Great weight, no. It is a part of it. But I did not give great weight to it because, as you mentioned, he reported that he used a substance. But that's not something where I'm hinging my decision solely on substance use.
What did you give great weight to?
What I gave great weight to was the personality profile type that he fit. For example, my understanding is that the one theory is that he planned, or he planned this murder because the victim was bound. So if you understand, or if you work with individuals who have a psychopathic or psychopathic personality, or who are a sociopath, you will learn that the details, as is mentioned in the theory that's been presented, is not consistent with it's not consistent with the evidence. Someone who would conduct an act of that sort, they build gradually. You don't just start out a murder in that type, or murdering or harming others in that type of way. That is a gradual type of violence or aggression. So what I was looking at his personality profile type, and then I also was looking at the different theories that were presented. And so what I'm saying is that we would expect to see other things within his personality profile type. There should be other violence or aggression. There should be other charges of violence and aggression. There should be there should be a known history of maybe intimate partner violence. There's a lot of things that should be within the personality profile type and within the evidence, given the theory that's been presented, that's not there.
How many of Mr. Chen's former girlfriends did you speak with?
None.
How many of Mr.
I
Chen's
expected
friends
people
did
involved.
you speak with?
None.
How many of Mr. Chen's family members did you interview?
None. I reviewed what was written in the discovery.
So you're basing your knowledge on Mr. Chen's prior violent history on what Mr. Chen told you.
And I'm also looking at the legal record, because you produced some charges for Mr. Chen in terms of violence and aggression, because typically that's what those individuals like that's what they have, at a much younger age than now. They start at 10, 11, or 12 years old.
You approached here. We're letting the jurors go downstairs to stretch their legs, and I don't want them to walk by and hear anything. We need just a minute to do that.
Yes, Your Honor.
We can proceed.
Yes, Your Honor.
Dr. Lewis, you can just hang out for just a moment. We've got to take a pause, then we'll resume as soon as we can.
Okay, y'all, while it's on a break, Wendy, I've talked to Wendy. She's coming. We're going to share a few articles about exactly what happened. So, as y'all, hey, Melissa, good to see you. I hear echo. I can't be mean. Because we saw where he went through self checkout. He rang up some of his cleaning supplies as asparagus so he wouldn't look guilty. But we got to keep in mind that this guy is trying to say that it was basically not what in his right mind. Does anyone know that I wasn't listening right there at the end? Did they declare him? Did they just take a break? Me too, Pammy B. And my throat's a little sore. Thank you for the super sticker. Thank you so much. Much appreciated. Oh, yeah, I don't want you to hurt them. Thank you for still listening, Dolly Green. It's going to get good. You know, Wendy, I jumped the gun a lot of times on stuff, but I was so excited about this case. Hey, Mama Stone, we're going to catch you up. This was so big here at the time. And then it was kind of like with Sarah Boone when by the time they got around to doing the case, it wasn't as big in Florida as it was for us, the people that still watching it, but it's not Sarah Boone status. Sore throat with white patches back. Oh, I hope we're not getting sick. I escaped the flu only to what? We'll find out. I'm definitely hearing something in the background. I don't know what it is. Okay. Let's see. We're very happy you're here, Melissa. I've missed y'all, and I've missed being on track with streams, and that's definitely something we got to get back to, especially with, and don't forget the Justice for Madeline Soto. That's coming up. I'm not really looking forward to going to that, but remember we any PayPal's, super chats, anything is going to that trip. There's going to be 2 of them. And hold on. Hold on, I'm getting a call. I'm going to
Hey,
Hey,
did you need me for something?
no, well, it said you was calling me, and then it said Wendy was leaving a message, and I'm like, what's happening with my phone?
No, I wasn't doing any of that. That's so weird. I was
Yeah, I'm
taking
just
Asher out
saying.
for listening. Sorry. Good morning. Hi, everybody. Sorry I'm late.
Okay, so they, I guess, were taking a break, and I was bringing them back up to speed as much as possible.
Really?
See what he's saying.
Okay.
Nothing. Well, that's not true. There is. But if we want to show the articles, then we can always catch up. I love opening statements because I think, well, you know what I think. But
What? I think opening statements are, hey, Melissa, how are you, honey? I hope so too, Pammy B. I do.
me too, Pammy. Me too.
We can always catch up if they start opening statements because they take forever. And we don't,
Mhm.
then we have less dead air. Because we can zip through the breaks and zip through lunch and all of that. So we'll catch up even if they start. Are they supposed to start opening statements today? Or is today just a
Mhm.
hearing?
So this is supposed to be trial day 1.
Okay.
Mm-hmm.
Have they started jury selection yet?
Yeah, it's done.
They have a jury. Okay, good.
Mm-hmm.
Good. Okay. Okay, well, I mean, yeah, if you want me to share this article that I just found, sure.
Yeah, let me. Am I still sharing? I am.
Yes.
Okay.
Yes, you are.
So here we
Okay,
go, y'all.
So here's an article that I just found. Let me see if I can zoom it in a little. Okay, so that's too much. How about like that? There we go. Okay. So he's facing life in prison if convicted in the death of his girlfriend. He's charged with first-degree murder and abuse of a corpse in the 2022 death of 22-year-old Jasmine Pace. Prosecutors allege Chen murdered and dismembered Pace before leaving her remains in a suitcase. I don't understand what people's obsession is with doing crimes with suitcases lately, but
And dismembering.
And dismembering. I know, right? Why can't we keep our victims in one piece, for God's sake? What the hell?
Yeah.
I swear, craziness. And look at him. He looks like a whole psycho.
But he don't today. You want to see him in court. He looks like a well-rounded young man.
Oh, no. He's a nutcase.
Yeah.
Pace's family reported her missing in November 2022, according to an affidavit. This is awesome. Pace's parents broke into Chen's apartment after tracking her location on November 23rd.
Go them.
I know, huh? Her parents told police they found Pace's identification and credit cards, but there was no sign of Pace or Chen. They broke into his house. I love that. I love that. Days later, police executed a search warrant and found blood throughout Chen's apartment. Her parents didn't see any of the blood. I'm glad.
Well, they use that, and I don't know if it's still luminol, but that's what they use, that type substance to.
So it was like small traces of blood, maybe.
Oh, they may have saw small, but when they sprayed it, it lit up like.
Do you have any pictures of that? Or did you see that somewhere? Did you see a picture?
I saw that. I did see a picture.
Let's try to find that. That'd be great.
Okay. It possibly could be in this article. Maybe there'll be a
No, this is the end of the article right here.
Look.
So crime scene technicians also determined there were attempts to clean the alleged crime scene. An investigator noted a large volume of blood had been cleaned up and there were signs of a violent physical altercation. So if they're trying to go with temporary insanity with this guy, I think I don't know how to say it. I think the cutoff for that or whatever, whether you can use that or not, is did he know that his actions were wrong when he did them? Did he know that his actions were wrong? And the fact that he cleaned up his mess, the stuff that he purchased at the Walgreens, the affidavit also references surveillance video that appears to show Chen purchasing cleaning supplies from a Walgreens and driving Pace's vehicle. He took her car to get the cleaning supplies to clean up her dead body. That's amazing. Pace's body was found December 1st in a suitcase. Her ankles were handcuffed and shackled to her right arm. Medical examiner determined she had been stabbed more than 60 times. Oh, wow. Look, there's a whole category of suitcase deaths. Wow. So Randy was telling me earlier that while he was at the Walgreens, he was he was doing the self checkout, and he ran up his cleaning supplies. He ran up those supplies as vegetables, Brussels sprouts, asparagus, whatever. So he knew what he was
I think it was
doing. He knew
asparagus, yeah.
it was asparagus. Thank you. He knew that he was trying. He on purpose tried to cover up what he was doing, which tells me he absolutely knew that his actions were wrong. So I don't know how they're going to get in anybody to say that he was, not mentally sound at the time. I mean, I'm sure he was not mentally sound, but he knew enough to know that, hey, Tawanda, good to see you, honey. Yes, you too. Hope you had
Hey,
a great
Tawanda.
Christmas. But he knew enough to know that his actions were wrong. He knew enough to try to cover them up. And I believe that's where the law says then you don't get to use temporary insanity, because he knew his actions were wrong.
Here it is.
All right. What'd you find?
The luminol. Let me see if y'all can see it. I tried to click on it.
Whoa. Is that her house? Or
Yeah.
His house, I mean?
Well, he broke into hers. You see it right there?
Wait,
then
they broke into his house.
Wait. I thought he killed her in her apartment.
It says Pace's family reported her missing. Pace's parents broke into Chen's apartment after tracking her location on November 23rd. Her parents told them they found Pace's identification cards and credit cards, but there was no sign of Pace or Chen. Days later, police executed a search warrant and found blood throughout Chen's apartment. This is his place.
Okay. Well, I guess I thought that said that he went to her apartment, but I was hoping. I don't know what I'm doing here.
If you visit that site right there, where does it take you?
That's what I did, and it took me here, and it's not giving me the option to scroll over to more pictures. Well, maybe
if you see underneath on the right hand where it says visit, if you visit that site, where does it take you anywhere?
Am I missing where it says visit that site?
So you see the picture that you have on the screen on the far right at the top with the luminol. Underneath that picture in a blue circle, it says visit.
Me and you. Oh, okay. Me and you, we are looking at different things. Let me just say that. And so when I visit that site, this is what pops up. You see that?
Yes.
And it's not view all photos, and then that's where it takes me. It doesn't take me to all photos.
Okay.
See?
Gotcha.
Sharing it now.
Gotcha. I see.
Wait, there it is. There it is.
There you go.
There's another one.
Can we zoom in at all? Oh, wow. That looks like a kitchen. Nope, that's not going to work.
I thought it was working there for a second.
I thought so too, but it made everything else weird.
Okay.
That's all right. Don't worry about it.
And there's that.
Wow.
Then there's that.
Wow. Dang. Holy shit.
Yeah.
Wow.
There's some more.
Wow. This stuff is pretty.
It kind of is. There's some more.
Wow.
And that's
grout.
Yeah.
There's blood in the grout.
So
Wow.
he just thought
under here? What is that?
Huh?
What was that on the other page? What's on the ground? Number 7.
I just assumed it was a rag, a towel.
Okay. Jeez.
Blood splatter.
Blood splatter with a towel right there.
See,
the fact that he tried to clean all this up shows me that he knew it was wrong. So he's never going to get he's never going to get insanity. It's never going to happen.
And I bet this is the other side of his carpet. See where it's cut over there?
Ah, yes. I was gonna say, like, why? What is that? Oh, yes, that's
Mhm.
the carpet pad underneath. They ripped up his carpet because he probably, scrubbed the carpet, but underneath all of that, he didn't get.
Yeah.
Wow. Wow.
There he is at the Walmart. I think
3A.
he's trying to be incognito.
It's
And
Walgreens. Not that it matters, but it's at Walgreens.
Walgreens. And
Yeah.
then there he
He's
is.
bringing up asparagus peroxide.
Bath towel, peroxide.
Wow. Raw
Um,
organic.
yeah.
Jesus. Asparagus, peroxide, bath towel.
Well, that's
Wow.
why I thought Walmart, because they don't sell asparagus at Walgreens, do they?
I don't know. The article said Walgreens, so I don't know. I have no idea.
Look how
Dang.
young. She's just a baby.
She's 22. Yeah, that is young. He looks like a whole psycho, though.
Yeah.
Damn. Oh, bless
Yeah.
him. Poor family. Look at him. Go to hell. Fuck you, nasty dick. Tomatoes.
Listen, if we're gonna be true crime people, it's innocent until proven guilty. Well, I think he admitted to it, though. I do think he admitted it.
I think, yeah, premeditated and stupid. Absolutely. Look at her. She's beautiful.
Yeah.
Why isn't he facing death?
I think I don't know.
Is
Does
Tennessee
Georgia
not a
have?
death penalty state?
Why did I say Georgia? Because so there's a part of Chattanooga that's in Georgia and part that's in Tennessee. But I
Oh,
thought Tennessee was a death penalty state.
you would think he would be facing death. All this premeditation, all the stuff that he did.
Mhm.
And if he dismembered her, why was she shackled?
Right. Unless he shackled her and then dismembered her. And that's where all the blood came from.
So was she still, was her arm still connected to her leg, even though it was not connected to her body?
We won't know that, I don't think, until the trial.
Oh my
Sorry,
God.
y'all.
Oh my God. Wow.
Yeah.
He is scary. He looks terrifying. Those pictures. He looks like a dark, evil force. That's what he looks like to me.
And it makes you think he's one of those that if I
Dead
can't have
eyes.
you, no one's going to have you.
Right. I'd love to know what his reason was. What was happening?
Wanda.
Did
Yeah.
she see through him? Was she like, I'm out of here?
Well, it said they met on a dating site and they dated just for a short time. So it's like one out of the two of them wanted it to end, and it wasn't him.
Wow.
What I was thinking.
Wow. 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 Wow.
Yeah. So
That is horrible.
and they are still no, she is still questioning that guy who I don't see how in the world he could possibly be labeled if he's not been in a murder trial before.
Well, what does it matter if he's been in a murder trial before?
Well, she said, how many times have you been deemed an expert? And he said, I would say 10. Well, that's not you. What do you mean you would say 10? It's either 10 or it's none. It's 2
Right.
or 3,
Well, he's saying it been deemed an expert where, though? In a trial?
Right.
Or did she leave it open? Deemed an expert where?
Yeah, she's letting him tell all of his stuff, but his stuff is scattered. And I mean, he seemed to be really busy. He said he came from humble beginnings.
Okay.
Oh, thank you, Melissa.
Oh, thanks, Melissa. I appreciate that. So is that guy still on the stand or no?
Mm-hmm. And put him back in.
Yeah, let's hear what he's saying. How much time did he spend with Chen?
50 whole minutes. So, he would be the expert.
No, we talked about this before. I do
Mhm.
not put any stock into paid expert witnesses. I just don't, because anybody can get anybody to say whatever you need them to say.
Yeah, and this was only last week, and he gave him 3 tests, and that can't prove anything that happened before the murder.
How could he possibly speak to Chen's state of mind at the time of the murder? How could he possibly speak to that? You can't, man. And the nerve of you to even get up here and do this. Why? You need a little clout? You need a little TV exposure? Like, that's disgusting. You're helping this guy get away with murder. Can you sleep at night, sir? I have questions myself.
Dr. Lewis, you can continue with what you were saying about.
I do think he regrets his decision a little.
I hope he does, because you're
So,
trying to help this man get away with
he
murder.
had a history of childhood trauma. He experiences symptoms of depression.
I don't give a fuck about his childhood trauma. Don't care.
There's no known legal history that I found. That's why I asked you if you found any charges in terms of.
He don't know anything about his trauma. He said that earlier.
It's horrible.
It is horrible.
Behavior within the school setting. So those are all the things that.
He misbehaved in a school setting. Real? Are you kidding me?
So did I.
Wow.
So there isn't a particular name, so to speak, of a profile. It's developing a profile of who this person or individual is. And you compare it to, as you mentioned, something like a sociopath or a psychopath, you would expect different information to be in the actual profile.
What does potential childhood trauma mean?
Yeah.
Well, the psychological testing revealed that there was likely a history of trauma. And then when he was inserted in during his childhood, a professional like me, and perhaps others, would likely characterize some of those incidents as abuse. However, Mr. Chen did not characterize it as such.
Mr. Chen said he wasn't abused,
Correct.
but you think he was.
However, he described.
Oh, so you think he lied to you?
Mm-hmm.
So if you think he lied to you, how can you possibly pause for a second? Pause.
Questions in his testing that you.
Pause for a second. One, Pammy B, absolutely, 100%. I do believe worst of the worst, they are afforded a defense. And a defense means they get a fair trial. I totally agree with that. They should get a fair trial. I don't like this kind of BS where some rando comes in and tries to help him get away with murder. He doesn't know anything about him. He's already admitted now that Chen's lied to him. So how can you trust any of your answers of your psychological testing? How can you trust any of them? If he's already lying to you about his childhood trauma or lack thereof, or he's hiding a trauma from you, you're just assuming that you know things that you don't. How can you trust anything he said?
Yeah, and how can we believe you?
You don't know if you got the right answers or not, sir.
You're just.
What is the purpose of this testimony right here? Is she trying to clear him as a witness, or is he actually testifying here?
She's trying to. She doesn't want him to be able to testify. She's trying to.
So she's trying to discredit this guy.
Yeah.
Okay. And they want all of his opinions thrown out.
Mm-hmm.
Okay.
Of course, now the good thing, the jury hasn't heard any of his opinions, and that's what she's trying to prevent.
Well, I mean, honestly, go ahead, put him up in front of the jury. They'll probably think the same thing we all think.
Yeah, I agree with that.
This guy's a buffoon. He's already admitted that Chen lied to him about his answers, or he believes that he lied to him about his answers. So you can't trust anything that Chen may or may not have even told you. You're just coming up with your own diagnoses without even knowing if you've got the correct answers after less than an hour. Get out of here. Get out of here.
During the interviewing, he told me about his childhood during the interview. So he described.
Were there questions on the test also related to childhood trauma?
Specifically childhood trauma, no. The testing was asking about, basically what the testing does, it's not face value. So it asks questions that may appear to be innocuous to the person who's answering or to the examination. However, based on how he responded in the testing the interpretation suggests that likely he has experienced trauma in the past. because he matches how other people who we know for a fact have experienced trauma is how he responded. So what we do is we do comparison groups. So we're comparing how he responds to items to how others who we know are known to have certain disorders or certain life experiences.
What was that childhood trauma that he denied having, but you found that he had based on what he was saying?
Good question.
The childhood trauma is not categorized as trauma.
This is where it goes too far.
Okay.
I'm also saying, Jason, we can get into it later when we get into witness is allowed to testify further and he is recognized an expert. And Mr. Josh wants to lay the foundation, you can ask him about the specifics later. Just saying at this point.
You'd agree, Dr. Lewis, that a majority of people with childhood trauma don't murder other people, right?
Absolutely. And I would never suggest that that would be an excuse for any type of law breaking.
Would your opinion change if you would have spoken with former friends of Mr. Chen that would tell you that they were scared of him?
That would be speculation. I don't know if it would change or not. It would depend on the veracity of the information or the details of the events that that his friends would say. So if there's information that's there, I'm more than willing to listen and to hear it. And yes, my opinion could potentially change. However, I have no way of knowing that until it happens.
Well, some experts would have interviewed people.
Ooh, a shade.
Yes. I think that is very much a common, I would say a common practice for some. However, it is not necessary or mandatory in terms of best practices, particularly not for mental status at the time of the offense or mental state type of evaluation. So I do certainly agree with you that does happen, but it's not necessary.
Why did you not come to Chattanooga to see Mr. Chen?
It wasn't even in person?
He had been moved to Nashville.
I did not know that until now.
We didn't even interview him in person. Oh my God.
And I was away on holiday December 16th through the 20th, and then I went out of the country from the 23rd or 24th until January the 3rd. And so I wasn't able to see him until January 7th. By that time, he was moved to Nashville, which is where I went to go see him.
Well, what about January 4th, 5th, and 6th?
Ma'am, there's no way I could have done that because I took a 24-hour flight from South Africa. So I needed to rest.
You didn't even see him in person, Randy. Wow.
Josh, at this point, we're still trying to decide whether.
He needed to rest, Wendy.
State objective to qualify as an expert.
Yes, Your Honor.
State your reasons why, please.
Your Honor, Dr. Lewis has he was licensed as a psychologist in 2021, so he has several years of experience as a forensic psychologist. Okay, I apologize, from 2021 in Virginia to 2020 in the state of Georgia. Of course, he's not licensed as a psychologist in the state of Tennessee. He, in fact, probably has expertise in some type of psychology. But having an expertise in some kind of psychology does not mean that you have an expertise in a defendant's mental state at the time of a criminal offense.
Thank
A
you.
podiatrist does not have an expertise in forensic pathology, even though they're both medical doctors. So no disrespect to Dr. Lewis, but as you go through, as we did, Dr. Lewis's resume, there is hardly anything in the resume or in his memorandum that has to do with reliability or trustworthiness of his findings as it has to do with the defendant's mental state at the time of the criminal offense. There's hardly anything. there is a lot regarding the defendant's competency to stand trial. That is not what we are here on. This expert cannot testify in toxicology. He is not, and I don't think this will be contested, he is not an expert in toxicology, which is apparently a primary issue of what he would opine on is the defendant's substance use on November 23rd, 2022 that he has no facts or information on except for what Mr. Chen told him. So he has no basis of knowledge. He is not an expert in the field of toxicology. He is not an expert in pharmacology. Sorry, Judge. Pharmacology. He is not a medical doctor. He has not presented enough facts and evidence of which he based his opinion on the defendant's mental state at the time of the offense. And in fact, Your Honor, the state is more confused after hearing this testimony because the defense alleged that the argument was diminished capacity, to which the expert adamantly denied that he was arguing diminished capacity. We now have a personality profile, childhood trauma. There's been nothing on the record that would establish that this expert should be qualified as a forensic psychologist as it relates to a defendant's mental state at the time of the offense. Moreover, he has not had enough time to speak with the defendant. He has not done his due diligence in checking the defendant's records, speaking with the defendant's family members or friends, and due to the fact that he's had the discovery since December 17th, it was on, quote, holiday and in South Africa for a majority of the time thereafter, he has not even had enough time to adequately go through discovery and make any type of finding such as this in this case. So we do object to this witness being qualified as an expert.
I do think that the bar, there's some standard obviously for letting an expert testify. I think that it's whether or not some specialized knowledge might be helpful to the finder fact in this particular case. He seems like perhaps he hasn't had the depth of experience that other experts have testified. Whether I don't think he has that yet. I don't think there's anything that's disqualifying as far as the weight that should be given to his opinion. That's certainly something we can talk about. But as far as against qualifications are concerned, as far as him being able to give an opinion, again, we're doing all this for the record. His testimony's already been deemed to be inadmissible, but I want the record to be complete. As much information as possible about Dr. Lewis. So I will recognize this witness as an expert in forensic psychology. Mr. Washington,
Before proceeding, Your Honor, I just want to.
Is he going to let him in or not? I can't tell.
Is the court finding that there was a violation of
I don't think so.
No, I'm not finding there was a violation in the sense that a deadline was missed. I do think that if you want to clarify my ruling, there are actually two aspects to it. The first is that it's clear that this expert's services for this purpose, for what we're talking about today, the defense felt it became necessary after a recent hearing last month where the monster exhibit was admitted, and there was some concerns about that as well as the medical examiner's testimony going to premeditation. So I think that based on the timing, so that the state is not unfairly surprised, the workaround that the court is crafting removes the major, if not the only reason that this witness's testimony on this issue was represented to this court was needed. So that's one of the reasons being excluded is that state, I want to avoid the unfair surprise that Rule 12.2 contemplates, as well as give the defense a fair shake, as he described in voir dire last week. So that's one of the reasons. The other is that I don't think that the opinion as written qualifies something that would be substantially helpful to the jury. when Dr. Lewis wrote that it's highly unlikely that Mr. Chen possessed the requisite premeditation. I do find that there's a degree of speculation that is not going to rise to the level where his opinion would be helpful. And also, I guess I can point it out now that during Dr. Lewis's testimony moments ago, he talked about the great weight that he gave to personality profile type. And it is pretty clear in case law that personality type is not something that's even relevant to the defendant's capacity to form a mental state. That's pretty well established. So there are numerous reasons that this witness's testimony has been excluded from this particular trial at this particular point. Those are the reasons. Not a 12.2 violation. Again, I don't think there's any bad faith. I think this way the circumstances unfolded, I'm not finding that the defense acted unethically in any way. It's the way that it unfolded, the short time frame. Yes, sir.
I'll need,
So it looks like you got the draw. Just kind of let them know.
You know what just happened, Randy?
They discredited him, right?
I don't know.
You can text.
I can't hear anything.
I can hear out of my right ear.
Is there any way you can adjust the volume? Can you kick that up at all?
No,
Damn.
no. See, it's all the way up.
Yeah. And your computer is all the way up too?
Yeah.
Now, who is this chick?
Now I think she's just the court reporter.
She sits that close to the.
I mean, I wouldn't want to, not usually, but maybe not.
That's really close.
You know, he's so disappointed. I was at Galifianakis there. See if I can go in settings and do anything about. Hello? No.
Was there just a moment ago. Now it's not. There we go. Dr. Lewis, sorry about that. We're going slow for lots of reasons, but I'm sorry to say that sometimes technology, this court moves at the speed of technology sometimes. Well, a lot of it's user error. Hopefully we solve that for now, okay? So I believe Mr. Weiss can ask some questions now.
Hi there, Dr. Lewis. May I have your overhead?
Yes.
If they make him get down to the mic.
Can he see?
I don't know if WebEx will operate with overhead at the same time.
They are allergic to using the microphone, I swear.
I'm telling you. Hey, Amy.
Hey, Amy.
Can I try work around, Judge? Unless the state's going to object, I guess it doesn't matter. Dr. Lewis, I'm holding what you sent to my office as a curriculum vitae. It says Douglas E. Lewis, Junior, BSYD at the top, and the top right corner is says REB period 9, 24. Is this your CV?
Yes.
For the purposes of this hearing, the defense moves to enter the CV of Dr. Lewis into evidence as Exhibit 1.
Yeah, for this hearing, not to go back to the jury.
May I approach you?
Sir, feel free to move on the court.
This is the first CV you sent us or the second CV?
Second.
My CV says revised 9/24 is the one. That's right.
Dr. Lewis, I have it. Dr. Lewis, I have a letter here from Regina Lewis at the board administrator at the Board of Examiner in Psychology. It's dated December 17th. Was this letter given to you authorizing you to practice law temporarily in Tennessee?
Practice law?
I'm sorry.
Practice psychology.
Practice forensic psychology.
The practice psychology, yes.
Defense moves into this is exhibit number 2. Dr. Lewis, I'm holding in my hand a 7-page report, or memorandum rather. It says the Honorable Boyd and Patterson, the top, dated January 11th, 2025. Is this your memorandum pertaining to expert testimony regarding Jason Chen?
Based on what you described, yes.
Defense moves to make this exhibit 3.
I guess they're letting him stay.
I guess so.
All right, Dr. Lewis.
I'm sorry. I'm shocked.
I want to ask you about the methodology that you used.
Well, the jury, I don't think is going to buy anything.
What validated psychological tools
No.
employ in your
Not after
system?
that crime scene.
No.
The psychological tools that are both valid and reliable are the TOBRA, the TSI-2, and the PAI, broadly and well-known instruments.
Are there, if you had more time to spend with Jason, are there other tests that you would have performed?
No. I mean, certainly there are numerous tests that we have at our disposal, but I don't think that would have been necessary. In fact, a lot of mental status at the time of the offense evaluations don't use testing at all because psychiatrists and psychologists perform. So a lot of times testing is not even used.
Are the methods that you use consistent with the guidelines recognized by professional organizations like the American Psychological Association?
Yes.
And you don't have to go through it, but are you able to cite research and case studies that support the evaluation analysis that you did on Mr. Chen's or Jason's psychological state?
Yes.
And is it relevant to premeditation?
Directly relevant to the issue of premeditation, just like most legal questions, there's nothing that's going to directly load on any type of legal issue. However, those are tools, yes, that are used to answer some of the legal questions and controversies that emerge.
Do you believe that you were provided all the relevant materials, including evidence including evidence to ensure that your assessment is objective?
That is objective, yes, I strive for objectivity, but as I mentioned earlier, with the introduction of more information or data that's objective, my opinion could change. However, based on what was available to me, as I mentioned in the memorandum, that is how I form those are the bases of how I form my opinion.
In your opinion, you say when to a reasonable degree of psychological certainty. What does that mean in the context of your opinion?
That means just like in any type of psychological science or practice, it is highly likely that what I'm saying is correct. However, when it comes to behaviors, actions, etc., we cannot say definitively anything. So that is what that means. That says that means that given the resources that I've been given, also the evaluation, the psychological test, etc., that to the highest degree to which is possible as a psychologist or a psychiatrist, this is what my opinion is. However, we can't say anything definitively.
Well, that's my question is, why can't you say this, your opinion with certainty? Absolute certainty.
It is. I am certain of my opinion. However, to say absolutely certain, I would have had to be in the room when these things were occurring, which none of us were. So I can't say this is absolutely what happened. cannot say that because none of us can say that. However, based on the information, the data, the testing, the evaluation, it is highly likely that the opinion that I reached is the accurate.
Would you characterize your opinion as based on speculation?
No,
Why not?
because
He seems a little
I
irritated, don't you
all
think?
the evidence that was in the discovery.
Yeah, probably because he doesn't like the idea of someone saying that, you know, he's not qualified to do any of this. But
legal history again, the things that are in the documentation. So speculation alone, based on my understanding, would be not using any form of evidence, not trying to use any type of objective psychological testing that's both valid and reliable. Those type of things, I think, I would characterize as speculation. However, when you use a multi-method approach, as I did, I would not characterize my final conclusion as speculative.
Did you make any assumptions that was unsupported by the evidence informing your conclusion?
No.
yeah, the evidence that you got in less than an hour,
So can you
didn't even
explain
meet
to
the
public
guy,
how your
No.
psychological insights from
didn't
your
even breathe the same air as the guy?
Jason Chen are relevant
We don't blame you.
to premeditation?
But sure, help him get away with murder.
Okay,
Great
so
idea.
premeditation is arguably something about one's mental status or mental state during the commission of an act. So just like any other
Yeah,
mental
like
status
changing
related
the
evaluation,
bleach to
I am
asparagus.
assessing and evaluating not only what
That
came
shows you
before,
got all your
during, and after the act, but also I'm also looking at
It shows that you know exactly what you're doing.
yeah, you're.
So I'm
All
using
his mental
I don't know what
faculties
word
are
I'm trying
right
to.
there,
things in order to answer the legal question.
right?
I got,
Typically,
yeah.
again, when it comes to
I'm
legal
putting my
questions, like competency to stand trial,
AirPod in and
mental status at the time of the offense, violence risk, etc. There's no
going to
legal
the drawer.
question that
Right back.
psychologists or psychiatrists can directly answer in the way that you all are trying to characterize it. What we do is we use all the information that we have available, data, interviewing, observations, testing, etc., to answer the legal question. But it's not like A plus B equals C. That is not how these things work. Like, for example, there's no real test of premeditation. There's no test of mental status at the time of the offense. We use the information that we have and the testing and the level of questioning and training that we have to make to give the court answers to its controversy.
So sticking with the premeditation, particularly in cases with premeditation or where you're dealing with intent, can you elaborate on the specific experience conducting those types of forensic evaluations?
So those type of I actually am in the middle of one. I have one that I'm doing that has to do with the intent or the case element of intent in Virginia. And in those type of cases, we're looking at one's functioning behaviorally, socially, and intellectually or cognitively in order to make determinations about one's intent. For example, it was posed earlier about his reasoning and critical thinking. If someone, for example, has an IQ of less than 65 or less than 60, there's certain types of crimes without the assistance of another person, you know that they would not be able to do because they don't have the level of forethought or thinking. In terms, that's an easy way of kind of understanding it. IQ or functioning in terms of their cognitive functioning is something where we would be able to answer that type of question.
So can you explain your role as a forensic psychologist and how it's distinct from a psychiatrist or a general clinical psychologist in assessing premeditation or intent?
A forensic psychologist is a clinical psychologist who has specialized or specialty training in forensic psychology, meaning we have gotten some type of legal training in that we understand understand or know how to interpret certain statutes, and we also apply psychological principles to legal time of the offense. These are legal issues. However, you need a psychologist or someone with that particular training in order to answer those questions. So we're different from, a forensic psychologist is different from a psychiatrist because a psychiatrist cannot issue testing. Usually their training in forensic is not as comprehensive as it is when you are studying to be a forensic psychologist. And we're definitely different from a general practitioner because general practitioners are there to treat and evaluate mental disorders only. They don't have the legal piece, the legal understanding. For example, I had 2 to 3 years of didactic instruction about cases that involve mental health or psychological issues.
What methods did you employ in forming your conclusion about Jason Chen's mental state at the time of the events?
I reviewed the entire discovery that was made available to me. I interviewed Mr. Chen extensively, not just questions about his personal history, but also violence risk and also sexual violence risk. Again, those questions were not all face valid, meaning there were times where an examinee would not know why I was asking the questions that I was asking. I also administered 3 psychological tests that are both deemed valid and reliable within our field.
So in regards to the assessments that you did on Jason,
Or I think Mr. Whiteford shuffling jurors around as far as figuring out when to do that, I should say. Please.
let me start over. The question is whether, or here, let me say this. Can you explain the psychological concepts of emotional regulation, impulsivity, and how they're relevant to this case?
So emotional regulation and impulsivity are important to this case because often people who commit murder or other heinous acts of violence, it tends to be in a heightened state or what I call affective aggression or violence. So someone who has trouble regulating their emotions or someone who is quick to anger and also is impulsive, they are likely to engage in behavior without thinking. And a lot of times, our jails and our prisons are filled with people who have committed acts out of being anger, not thinking, impulsive. So emotional regulation and impulsivity are 2, in my opinion, major factors in most crimes when it comes to aggression and violence.
So one of the tests you did was, is it called TOBRA? How do you pronounce it?
It's called the TOBRA.
And you conducted the TOBRA with Jason Chen?
Yeah.
How did his performance in this test inform your understanding of his cognitive capacity for planning?
Well, the reason why I issued that test is because someone who is highly intelligent will create a different type or may slightly change the way that we characterize in terms of the profile. Because someone, and so I needed to know where he fell in terms of the bell curve, in terms of intelligence. So it's not a test of intelligence, but one of reasoning and critical thinking. And so if he is scored really high on there, that may have informed me in a different kind of way about how he's functioning in terms of, his proclivity perhaps for manipulation, deception, lying, etc. And so I need to know where he fell. And so I know that he falls in the average range on the bell curve in terms of, reasoning and critical thinking.
Is your opinion and conclusion based solely on that personality test?
It is that is a test of reasoning and critical thinking, and no, it is not based solely on that. No opinion should be formed based on one thing. It needs to be a multi-method approach.
In the TSI 2, you noted Jason had anxious arousal and intrusive experiences. How do these findings support your conclusion that Jason's actions were likely reactive and premeditated?
In terms of supporting it basically builds a profile of how he's functioning. This is someone who likely has bad memories about something that has happened to them, experiences anxiety, which, you know, is worry or restlessness. Individuals like that may be quick to agitation. They may engage in behaviors to reduce tension, like using marijuana or alcohol. This is developing a profile of how this person is functioning daily.
How does your reliance on the empirical testing, using those the tests that you and I guess the evidence and discovery that you received, ensure that your conclusions are not speculative?
It strongly ensures it because best practices indicate by the specialty guidelines of forensic psychology, which were adopted by the American Psychological Association in 2013, indicate that you should engage in a multi-method approach when it comes to evaluation assessment. And therefore, based on that adoption of those specialty guidelines, based on my work in the field of mental health since 2010, my work with inmates or justice involved individuals since 2014 or 2015, it ensures me and it informs me that my opinion is not speculative.
Were your findings consistent with other peer-reviewed literature and established psychological principles?
My findings were consistent. Let me answer that in a different kind of way. The approach and the procedures that I used were consistent with any type of empirical research or examples, etc. My findings or my opinion is something that I reached based on using those methods that were consistent with all empirical research that's available.
Were the methods that you used, the forms that you used, were those reliable?
Yes, those tests and or forms, however you want to refer to it, have been used for years by psychologists across the nation. You can easily Google them and you can learn about a lot of these tests. And these testing are well developed. In particular, the personality testing sort was developed by Dr. Leslie Morey at the University of Texas, and he's still doing research on that testing. So it is very reliable.
Is it that your findings and conclusions that Jason Chen couldn't have formed the requisite mental state premeditation? Is that your opinion?
My opinion that it's highly unlikely that he formed the requisite premeditation.
Wow.
Just let the jurors walk by, but we're done. One more question. All right, go ahead.
Would any reputable forensic psychologist say with absolute certainty that a subject had the requisite premeditation or requisite intent, or is that something that goes too far beyond an opinion?
Saying absolutely certain is going too far beyond an opinion. No reputable forensic psychologist or forensic psychiatrist should say anything with absolutism.
Thank you, Dr.
Just one, Joe. You can send the jurors to one. Yes, Judge. Council protocol 2 minutes.
Wow. I don't know. Randy, are you still around? I think Randy was doing some laundry or something too. She's probably can hear us, but she can't talk right now. I don't know. Yeah, he cannot say that with certainty, but he can speak to. He can say that it wasn't premeditated. He said that pretty certainly, which seems strange to me. How can you possibly know? I don't know. This guy seems like a waste of time, but whatever. Let the jury see him. I don't think they're going to believe him any more than we do. Did he, when he got all that cleaning supplies and stuff, was that before or after she was dead?
Yeah, I ran back. Let me throw this.
Do you know? Did he
Do
get
what?
did he get the cleaning supplies before or after she was dead?
I was assuming it was after, but here's what I thought.
Hit pause.
Yeah.
The thing is
Absolutely.
that
Thank you so much.
earlier, he
This is why we're
said,
getting
"Well,
started.
none of us can say that because we weren't there." But now he can say it wasn't premeditated because
Right. How can he
what was?
possibly know if it was premeditated or not?
Mm,
And the fact that he got all those cleaning supplies, I want to know what the timeline is on the cleaning supplies. Did he do that before or after? A, and B, all of that stuff still shows that he knew what his actions were, that they were wrong.
right.
So whether you think it's premeditated or not, I don't know, that this just doesn't, 60 times, being stabbed 60 times, dismembered, shackled, put in a suitcase, cleaned up as meticulously as possible. None of that speaks to impulsiveness to me.
No, that's a plan. That's a
Yeah.
whole plan.
I'm not seeing a lot of impulsive behavior with that.
I'm a little shocked at his testimony, to be honest.
I'm surprised the judge is letting it in.
How we're going to
Me
proceed in
too.
this case. I do thank you for your time this morning. Okay?
Absolutely. Thank you. It's a privilege.
So the jurors just been sent to lunch. They've got Jimmy John in the jury room, which means it won't take them very long. We'll give them a little time to walk around. So this will be our lunch break too. Are there any matters you want to take up before we take our lunch break?
Yes, Your Honor, two separate issues. One has to do with the indictment. The state has indicted Mr. Chen for abuse of corpse. In that indictment, we listed all of the factors under the abuse of corpse statute, two of which inarguably do not apply and would be prejudicial if they were read to the jury. One of those is disinterring the corpse that has been buried or otherwise interred. The other is the other one is engaging in sexual contact. Neither of those are being argued by the state, so I would just request that I be able to leave those out when I read the indictment and only read the other two subsections that could apply in fairness to Mr. Chen. And then the other judge, so that the defense can object before opening statement, the state intends to introduce the suitcase that Ms. Pace's body was in during opening statement to avoid delay during opening statement where the jury has to go out.
What did she say? I can't hear what she's saying.
They're gonna show the suitcase.
Show the suitcase.
Yes, Your Honor.
Otherwise, it's common for evidence that's likely going to be admitted to be used in opening. Any objection?
Thank you,
Well,
Judge.
to the extent of all my past motions to suppress all those.
Not waiving anything.
Thank you, Judge.
All right, that clock says 12:20. Everyone will be back when that clock says 1:15. That's 55 minutes of lunch. What we're going to do is start the jury trial, bring the jury in. They'll be sworn. We'll get instructions. And remain seated down. We're still in session.
Now it's lunchtime.
Still in session. What happened is the jury will be brought back in. They'll be sworn. Or we did preliminary jury instructions to them, state the indictment, we're in the opening, you're the person.
Yes, Your Honor. What time did you say? I apologize.
It'll be 1:15.
1:15. Thank you, Your Honor.
The court's in recess to 1:15.
I know at 1:15, are they going to do opening statements or?
That's the way I took it.
Okay.
They're gonna go through all the y'all can't do this, you don't listen to this, don't cheat off your partner, all that.
Yeah, the opening jury instruction stuff. That's
Yeah.
not final jury instructions yet.
Mm-mm. No,
Wow.
that was a
I don't
lot.
know. I don't know about
Actually,
that guy.
I don't either.
I don't understand why he's even being allowed in there other than, when the jury hears him, I don't think they're going to be impressed.
No, they're gonna know. Well, this guy's for sale.
But that's what I think of every expert witness that people bring in. Every time, defense or prosecution, doesn't matter. Anytime anyone puts their expert, air quotes, expert witness up there, I think, paid. That's what I think. Sarah Boone, perfect example. They got two expert witnesses to get up there and say the exact opposite of one another. I mean,
That's
it's ridiculous. It's a waste of time.
I always like to think the ones that are with the prosecution are not paid and they're doing it because they know it's the right thing to do.
Well, that's what I was thinking about this guy right here. Like, at the end of the day, sir, you're up there trying to help this man get away with murder. Like, how do you feel about that? You feel good about that? You feel good about yourself? Like, is the money worth it? I'd love to know.
Right. And then, let him do this so we can get more jobs, more,
Right. Is that what this is? Is that what this is? Is clout chase? Like, honestly, you selling your soul to the devil over here?
Seems like.
You want to help this guy get away with his murder, huh? That's crazy.
I gotta say, I'm truly, shocked that there's not more stuff out here about this murder.
Well, it was several years ago.
Yeah.
I know,
2023.
Pammy B, you're right. And maybe I'm just being cranky because I haven't had breakfast yet. Let me settle down a little bit. You're right. They have to put on a defense. I do. And I understand the defense. Like, they need to make sure he gets a fair trial. But that doesn't mean we bring in paid experts to help him get away with his lie. Like, do you see there's a difference? No?
Yes. I don't.
I think I do, Pammy B. Yes, I do. I want a Snickers. Like, I want this guy to get a fair trial. Of course I do. Honestly. But to pay experts to come in and help him get away with his lie, no. I don't want that. But whatever. That's why I'm not a lawyer, I guess. One of the many reasons.
one of the few. Not me.
Right. One of the few reasons.
So, should we shut down for an hour and come back or what?
Yeah, we can if you want. Yeah, how long have you been live? 3 hours? Jeez. It's a long time, girl.
Yeah, I'm feeling it.
Okay, yeah, let's shut down and come back in an hour.
Okay.
Or whenever let's make sure they're doing opening statements first. And if they are, then we'll come back.
Yes. All right. We'll see y'all then.
All right, bye guys.
Wait a minute. Wrong button. There we go.